And for everyone joining virtually, thank you as well. For Government Law Review's portion of the program today, High Stakes, the Legal, Ethical, and Policy Implications of Cannabis. My name is Caroline Drinkard, and I'm the Editor-in-Chief of the Government Law Review. We are delighted to take over. We are delighted to take over where Jason Klimek, Corey Auerbach, and the Government Law Center left off this morning. And we're looking forward to an enlightening discussion with our panelists this afternoon. Thank you. Before we begin, I would just like to extend a sincere thank you from the Government Law Review to several individuals who made this event possible. Thank you to Lauren Minot, Julie Pierce, John Collins, and the Administrative Services team for helping with the logistics and marketing for this event. Also, thank you to Katie Palmieri for your constant support for the symposium and honestly for every journal event. And thank you to our faculty advisor, Dean Ray Brescia, for supporting us from the very start of our planning back in June and encouraging us to collaborate with the Government Law Center to bring you a cohesive event today. Finally, I would like to thank Rachel Brown, the architect behind this afternoon's program. Rachel has been working on this project for at least the last 9 months, and it is clear that she put her heart into this event. She has assembled speakers from across the country and across disciplines to provide a multidimensional conversation on cannabis law and governance. I am so excited to see the product of her efforts unfold before us and to hear from this impressive group. Without further delay, I would like to welcome Rachel Brown to the podium to introduce the lineup for our conversation this afternoon. Thank you.
Hi, everyone. My name is Rachel Brown. I want to thank you all for being here and everyone virtually as well, and just reiterate my thanks to everyone that Caroline also expressed our gratitude to, both behind the scenes and here today. I'd like to thank our panelists, moderators, and all of the GLR volunteers that really helped me to not go absolutely crazy today. So a big thank you to all of you. We're so grateful for your support and different expertise. I would like to extend a specific thank you to Chell Miller in the Government Law Center, who really helped with everything and is a complete expert in these types of events. And when I was lost, told me where to go every time. And this really would not be such a great event without their help. So thank you, Chell, and thank you to Caroline for just always being a sounding board for me and supporting and leading our journal. I'm thrilled to welcome everyone to today's symposium on cannabis law and governance. We're at a critical moment in the evolution in this field. Cannabis regulation is shifting rapidly. The landscape, it's complex, it's multi-layered. There's federal, state, municipal, and tribal governance intersecting, overlapping, and each playing their own unique role in the industry. Today, we have an opportunity to hear from experts who are deeply involved in the ongoing discussions and the policymaking efforts surrounding cannabis. Sorry. We'll be diving into two important areas: the regulation of cannabis at various levels of government and the importance of equitable development in the cannabis field. Our first panel, which you see before you, will explore how cannabis is regulated at federal, state, municipal, and tribal levels. With federal prohibition still in place, but state and local governments moving ahead with legalization, the question arises, how do regulations at these different levels intersect, conflict, and sometimes collaborate? We'll hear from experts who will provide insights into the challenges and the opportunities that face different levels of government when regulating cannabis and the ways in which they are navigating the landscape. Our second panel will focus on equitable development, a topic that's crucial for ensuring the benefits of cannabis legalization are distributed fairly to the communities affected. From licensing to business opportunities to reinvestment in those communities, there's a tremendous opportunity for us to create more inclusive and just cannabis industry. And today's speakers will discuss the frameworks, the policies, and the initiatives that can help address the historical inequities and foster a meaningful change. The symposium is not just a chance to discuss policies and laws. We want this to be a space to engage in meaningful conversations about social, economic, and cultural impacts of cannabis policy. So I encourage everyone to ask questions, to challenge assumptions, and to think critically about the future of cannabis policy. So before we begin, I'd like to thank all of our panelists for their time and their expertise. We're honored to have all of you here. And your contributions are invaluable to our conversation. And I just once again want to thank everyone for being here. So without further ado, Professor Ava Ayers is our moderator for the first panel, and she will take it from here.
Okay, thanks so much. I'm going to be very brief, except to say thank you so much to Carolyn and to Rachel for all of the work that you've put into this. So we're going to be hearing from 4 panelists today, and then we'll have time for questions. So do be thinking about questions as you listen. And I'm going to skip the extended introductions. You can see lots of their amazing biography in your panel, in your program. We'll start with Professor Robert Mikos, who is the LaRoche Family Chair in Law at Vanderbilt University Law School. Then we'll hear from Jasmine Higgins, who's a partner and chief operating officer at GLS here in Albany. Lisa Brunner, who's the chairwoman of the White Earth Ojibwe Nation Medicinal Cannabis Control Commission. And finally from Matt Leonardo, who is a principal at Hinman and Straub working in the field. So Professor Mikos, over to you.
Thanks, everyone. I'll see if I get the sound. There we go. Thanks, everyone, for including me in this. I appreciate the opportunity to come out here. I'm going to start not through any design of the panel, but I'm going to start with the federal government. And there are developments at the federal government. One development in particular that is pending. As Rachel mentioned moments ago, we all know right now the federal government has this absolute prohibition regime where marijuana in any form is unlawful. Doesn't matter if it's for medical purposes, adult use, it's all the same under federal law. The impending development, I'm sure you've all heard about it. You'd have to have been hiding under a rock for the last 18 months not to have. But it's a proposal from the DEA to move marijuana off of Schedule 1 under the Controlled Substances Act, move it on to Schedule 3. That's called rescheduling. And this is in the news all the time. People are following this very closely, following all the drama that's going on in DC. You know, is the DEA administrative law judge going to be kicked off the case? Is the DEA going to be removed from proposing its own regulation? There's a lot of crazy stuff going on in DC. But what I want to provide you with today is to try to tamp down a lot of the hype surrounding rescheduling. As Dave Posen has said, I want to provide some realism about what rescheduling actually means and what it will accomplish. And kind of hate to start the panel off this way, but I want to suggest that rescheduling is not such a big deal. It's not going to change things on the ground much, if at all. And I'll walk through very briefly in the time I have today why I think that's the case, why I think rescheduling isn't going to accomplish what a lot of people hope it would. One reason is that even if marijuana is moved from Schedule 1 to Schedule 3, it's still a controlled substance. And it's still going to be subject to a litany of regulations under the Controlled Substances Act. Think about other Schedule 3 controlled drugs, Adderall, ketamine, codeine. It's not as if anybody can just go out into a laboratory and make these things and sell them. Under federal law, even under the CSA, you have to get a license from the DEA to handle any of these substances. What's more, you can only deal with other vendors who also have such a license. So if you're a retailer, and even if you get a license from the federal DEA to sell a Schedule 3 drug, you can only buy it from other people who are licensed to produce that Schedule III drug. And you can only sell it to people who have a prescription, not a recommendation, which is normally what's now provided under state law. So there are lots of regulations that apply under the Controlled Substances Act. They're going to linger even after rescheduling. I think most companies out there that right now have a license from the state to sell marijuana for medical purposes won't be able to satisfy all the requirements to get one of these licenses from the DEA to sell marijuana federally as a Schedule III drug. And if you're an adult use supplier, it's out of the question because the CSA only allows the medical, the sale of substances for medical purposes. So for that reason alone, I think the impact of rescheduling, moving marijuana from Schedule I to Schedule III is fairly muted. But the other big reason why the impact is muted is because there's another statute that we've kind of ignored for marijuana to date, but it's going to have just as big an impact as the CSA does now, and that's the Food, Drug, and Cosmetic Act. Marijuana is going to have kind of a weird and not such a great status if it's rescheduled. It's going to be just about the only controlled substance that hasn't been approved by the Food and Drug Administration as safe and effective for medical use. The FDA made clear when it was recommending to the DEA, you really ought to reschedule this under your statute, under the CSA. The FDA made clear, we are not approving this drug. No one has run this through the necessary scientific clinical trials, so it is not an approved medication. There's really no other drug out there that's on Schedules 2 through 5 under the CSA that hasn't gotten FDA approval. So what does that mean to lack that FDA approval? Well, lo and behold, it means it's illegal to sell this drug, just like it is today. The status hasn't changed. The Food, Drug, and Cosmetic Act bans the sale, especially across state lines, but even using inputs from other states of medications that haven't been approved. So even within the medical market, things won't change. And the problem here is if you can't comply either with the CSA or the Food, Drug, and Cosmetic Act, or likely both of these, all the headaches that now face the state licensed cannabis industry, all the problems that they now encounter because federal government bans this particular drug, problems like lack of access to banking, the problems like not being able to get trademark protection under federal law, not being able to tap into the federal bankruptcy system, all those problems remain. If you're a big bank, if you're Citigroup, if you're Bank of America, you're still not going to bank this industry because everything they're doing remains a crime, even after rescheduling. It's a crime maybe under a different statute, doesn't make a difference to them. Everything they're doing is unlawful. You can't register a trademark with the USPTO if you are breaking the Food, Drug, and Cosmetic Act. They'll simply say that's not lawful use in commerce. When you sell your good with your brand attached to it, you can't register that trademark. So not a lot is going to change for the industry, with one exception. One concession I'll make, 280E, that dreaded tax provision, that obscure provision of the US tax code that says if you are a dealer in Schedule I or Schedule II drugs, you can't deduct your operating expenses when you calculate your federal tax liability. That basically means that the marijuana industry right now is paying exorbitant effective tax rates to the federal government. That would go away simply because on its face it applies only to Schedule I and Schedule II drugs. So whether you're a state licensed marijuana supplier or an illicit dealer, you no longer have to worry about Schedule or Section 280E. Although I'll note, even this one probably is going to be less of a concern regardless of rescheduling, because if the Trump administration succeeds in its push to further lower the corporate tax rate, 280E becomes less and less of a concern. You have the tax rate goes from 21% today to 15% tomorrow to 10% 2 years from now to 0% maybe in 3 years. You don't worry about 280E anyway, but that would be a concession. But I want to suggest that's an awful lot of effort to go through, pushing this drug to be rescheduled just for a tax break, if that's all it amounts to. I want to close by just kind of noting, I think this exercise of walking through all the different statutes that apply to these different substances, it suggests marijuana just doesn't fit neatly with the model of what the federal government was thinking of when it passed statutes like the Controlled Substances Act, the Food, Drug, and Cosmetic Act. There's really no other example we have out there that is a drug that has some popular medical uses, but also many recreational uses. And this is a drug that doesn't neatly fit into the regulatory models that we've designed, and I think probably calls for doing something very different. In the same way that we treat alcohol very differently. We don't subject it to the Controlled Substances Act. Nominally, it's subjected to the Food, Drug, and Cosmetic Act, but the FDA kind of throws it over to alcohol, tobacco, firearms, and explosives and tells them, this other federal agency, you handle this particular substance. So I just want to suggest that don't get your hopes up that the world is going to change a lot when and if and when the DEA actually reschedules marijuana. It's not going to be a huge impact on the ground. More work needs to be done, probably by Congress, but certainly more work needs to be done to kind of normalize this industry.
My name is Jasmine Higgins, and prior to my departure from city and local government, I was the chief equity officer and special advisor to Mayor Kathy Sheehan. So when New York State promulgated the cannabis law, municipalities were tasked with creating rules and regulations regarding the time, place, and manner of cannabis operations. So this applied to dispensaries and on-site consumption sites, which have not yet come alive. So the city was tasked with making sure that cannabis businesses were allowed to operate in a manner that was not unreasonably impractical. So this required making sure that the cannabis use was similar to other similar uses such as alcohol. So the city uses what's called the Unified Sustainable Development Ordinance, the USDO, which is a planning and land use management tool. Before or when the state initially made cannabis legal, our USDO treated cannabis and classified it similar to methadone, which is a controlled substance, kind of similar to the schedule that Dr. Mikos was talking about. So in order to ensure that cannabis businesses could operate and have a chance at economic development and success, we had to significantly alter our USDO. This required a series of definition changes, it required a policy review of the zoning districts that currently existed. So in the USDO, cannabis and controlled substances were allowed to operate in light industrial districts, which were only 2 areas within the city. This would not allow for substantial growth or reasonable operation of a cannabis business. So the city of Albany engaged in a nearly year-long public process where we created an advisory committee consisting of individuals from various backgrounds, public policy, cannabis cultivation, law, and a slew of other fields, including some of the interested operators. We created this advisory committee to make sure that the zoning changes that we were looking to enact were socially equitable, were reasonable in terms of the business operation and requirements, and informed by the local community, because part of the law allowed for the state to enact their side of things and then the city to manage and create their own set of operating rules. And so this process included a series of public meetings. It included some policy reviews and research from our planning and zoning team. We heard from some local lobbyists. We worked with the State Office of Cannabis Management because we were all building the plane and flying it at the same time. And so you had to be able to be flexible in terms of your policy changes and your legal changes. Otherwise, we were at risk of making local business operators unable to grow their business. So the USDO requires legal changes that require legislative changes. So this had to go through the Albany Common Council, and so each level of government at the local level included the executive and the legislative branches. We went from having these 2 districts to passing zoning changes that allowed for cannabis to be used as of right in 7 districts and conditionally permitted in 3. And what that means practically is that it reduces bureaucratic burdens on potential prospective operators. So if you were initially looking to secure a space in the city of Albany, you would have had to complete significant paperwork. You would have had to go to the city clerk's office, the planning board, the zoning board, the BZA, all of which could take 6 months, which then limits your ability and your funds to successfully practice and grow your business. This looked like many public meetings. It looked like a lot of presentations before the Common Council, many internal intergovernmental conversations, and a host of other things. But the primary focus was ensuring that cannabis economic development was permissible in the city of Albany. Hence these zoning changes that occurred. In addition to that, because of the local excise tax, which is a 3%, 4% split, 3% goes to the cities that have opted into cannabis, 1% to the counties. So the city of Albany, with its first dispensary, would get a percentage, that 3%, to a discretionary fund that then allowed them to decide how to utilize the funds. And a lot of the community interest was in socially equitable reinvestment in a manner that promotes workforce development, economic development, and a slew of other initiatives. So that has yet to be seen in the city of Albany, which requires additional public input, but how do we use the tax dollars that are now allowed in the city because of this economic development and land use policy change? I see some of the folks from the Office of Cannabis Management here, but we have all worked together to ensure that we can upstand these businesses in the city in a meaningful way that also accounts for the historical underrepresentation and criminalization of cannabis operators, users, and so on. So my primary focus was reducing bureaucratic burdens and making sure that the process was equitable. We put together a team of nearly 17 people from various junctures and policy backgrounds, so on and so forth. But we were able to create a process that allows for the first dispensary to open. And since then, we've seen 7 dispensaries open here and growing. But we also had to ensure that there was not an oversaturation to ensure the public convenience aspect is there. So 1,000 feet pools had to be included in the city zoning code so that you wouldn't see 2 cannabis shops next to each other or prospective on-site consumption immediately next to each other, which would then curtail those businesses' ability to grow their own business successfully and operate to the full extent. And so that was really the brunt of what I worked on. And now in the private sector, we are trying to determine the policy for reinvestment. So we have interested individuals, including local government, who want to make sure that the tax aspect is reinvested sustainably in a community. So whether it looks like supporting housing, workforce development projects, or childcare, things of that nature that allow for this market to really grow and flourish in a meaningful way. That is the brunt of it. This work was ongoing, but the state has the primary authority to promulgate the rules, and the city is very limited to time, place, and manner.
Bonjour. I will introduce myself in my culture. So bonjour, hello, Minugijigad, it's a good day. Maingandurem, I am Wolf Clan, Gawababiganagag and Dunjaba. I am from the White Earth Ojibwe Nation. Wasewagakwe Indigenous, I am Tornado Woman. So I had the privilege and honor to be invited here, and I thank Rachel for that, to understand what that landscape means at every level. And oftentimes, Indian country or Alaskan Natives are often forgotten about or an add-on to a sentence that sometimes can be very detrimental to our safety. So White Earth Nation and Red Lake Nation, we are the first tribes in the state of Minnesota. Oh, you're fine. To have indoor cultivation facilities. The state of Minnesota passed HF 100 bill in July of 2023. And when that occurred, that opened, yes, that opened the ability for tribes to be able to transport cannabis off the reservations, to be able to utilize the state's laboratory for third-party testing, those types of things. And then to be able to sell cannabis for adult use or recreational use. Up until that point, all that we have had was medicinal. So Red Lake was the first to open their dispensary on August 1st, and so they were the first tribe to do so. And then August 3rd, a couple days later, we were the second tribe to open our dispensary to sell cannabis for adult use. With that said, White Earth Nation is the first tribe in the state to have a tribal medicinal and adult use cannabis code and subsequent regulations. And then we were also the first to have a cannabis regulatory agency, which is the Medicinal Cannabis Control Commission. Our commission is made up of 3 positions, the chair, vice chair, and a commissioner, which is grossly underfunded, well, not underfunded, but undermanned. What our tribe did was recognize the need to be able to mirror the state of Minnesota with their regulations. And the reason being was so that we couldn't be targeted, if you will, by a federal agency where, because, for a discrepancy or an action taken, because then that would they would have to look at the state. So when I say it was a heavy lift, it was a good heavy lift. So, but from cannabis, from my perspective, is the first time that I've seen a semi-even playing field for tribes and state with cannabis laws concerning federal laws. And that's just from my perspective and my position for my tribe and my state. I can't speak to other tribes and the relationships in that capacity. But when I think about oftentimes when federal laws and policies are designed and the impact to tribal nations, like I said, are often an afterthought or an add-on to a sentence that can be detrimental to our life. So this is the first time I've seen an even playing field in that capacity on the federal level. Tribes, however, are limited if the state does not legalize cannabis for medicinal and or adult use, recreational use, and or both. So there are tribes within states in which the state has not legalized cannabis. A tribe may do so on the reservation, but then again, you've seen tribes get raided or threaten to be raided by the federal government in different states. So we are in a unique position with the state of Minnesota. Oftentimes Minnesota, or people look at us as a friendly state when it comes to its relationship with tribal nation. So our Governor Waltz and Vice and Lieutenant Governor, who happens to be an enrolled member of White Earth, Penny Flanagan, had made a concerted effort that most governors previously didn't do, and go and visit all of the tribes within the state. So from a government to government relationship, that was key. And it helps to build the ability to be good neighbors. So, but the limitations to if a state does not legalize, especially on a adult use recreational, is, for example, we could not utilize their testing laboratory. And we could transport cannabis off the reservation and trade with other tribal nations because that's government to government relations for tribes. But we couldn't necessarily transport elsewhere or utilize their facilities. So in according to our own code and regulations, because we mirror the state, we could not sell any of our cannabis unless it was tested. I called all of the universities to see if they had the capacity to test. I contacted agricultural colleges, other research venues within the state, if this is something that they would have the capacity to test for, and they couldn't. So our hands were tied until that bill passed. So with the federal government, they have their 8 federal priorities. So for example, can't sell to someone under the age of 21, to minors. You have to prevent cannabis from crossing state lines, even though that state may have legalized cannabis. You have to ensure that cannabis revenue is not diverted to a gang, mafia, or cartel, or used in other illegal activity, and so forth. So you have the Cole memo that was passed in 2013 that prioritized those priorities. And then the Wilkinson memo extended that guidance provided in the Cole-Wilkinson Cole memo to Indian country. So what that memo did, it acknowledges and recognizes tribal sovereignty with the same deference that's given to the states. So again, it's recognizing, where the Cole memo didn't include us, the Wilkinson memo remedied. The Sessions memo then basically rescinded it, but there was, very little practical changes since for that federal enforcement property or policy. And then you have the amendments that extended into March 24th with, I can't say his name properly, FAR amendment, and basically prohibits the DOJ from using funds to interfere with state rights to establish and regulate their own medicinal cannabis program. And it's in the federal budget bill. So what I wanted to kind of outline that for federalism and cannabis law is that you have 575 federally recognized tribes in the state or in the country. 300 plus are in what's called public law 280 states. What that means is that we are under the subject of the states for criminal jurisdiction and some civil regulatory, except for Red Lake Nation in Minnesota and Boys Fort, because they did a reassumption of concurrent retrocession in about 20 plus years ago. The others are, 200 plus are non-public law 280, which they're under federal jurisdiction, which is the Bureau of Indian Affairs and the FBI. And then in 2010, President Obama signed the Tribal Law and Order Act, and that allowed the opportunity for tribes in public law 280 to do a retrocession back to the federal government. And our tribe was the first to do so. So that creates an interesting dynamic because now we are both under state criminal jurisdiction and federal jurisdiction. So feds essentially pick and choose what they're going to investigate or the cases they may take. Typically, we would see that in drug raids because you see their black SUVs rolling down the road and other high-profile murder cases. Not that we've had a lot, thank the stars. So in summary, the federal landscape with tribal cannabis is equitable with the states that have legalized cannabis that has been pointed out. And so with states, that is unique to each tribe and the state. Not all work effectively as Minnesota and White Earth have, or as other tribes may have in other states. White Earth is currently working on the state of Minnesota, with a compact agreement. And excuse me, I had a typo in here. It was up to 5 dispensaries off the reservation. So this is the first of its kind in the country where tribes would be able to have 5 licenses off the reservation to have dispensaries. So right now, the compact is still in editing form. Negotiations hasn't necessarily been officially started. And that compact then would determine taxation, jurisdiction, seed to sale, track and visibility, and all of the other regulatory aspects that come with that. So with that, I want to say thank you. Thank you to Rachel and Albany Law School for the invitation to be here.
Hi, everybody. Can you hear me? You know what? I don't actually even need it.
You do for the phone recording.
Oh, recording. All right.
Testing, test.
Yeah, maybe we should. There we go. There we go. Thank you guys so much for having me here. Really big thank you to Rachel for organizing and staying on me to participate. You know, I just want to give you a little context about my background so you guys can understand why I'm talking about what I'm talking about. I'm a lawyer and a lobbyist at Hinman Straub in Albany, one of Albany's oldest law firms and the oldest government affairs firm in the state. So on the legal side, I do cannabis licensure, cannabis transactions, real estate, leases, compliance audits, you know, the whole gamut. And legislatively, we represent the Cannabis Farmers Alliance, the Black Cannabis Industry Association, the Seneca Nation that has interest in cannabis, and a lab. From my perspective, we work on the legal side with retailers, brands, processors, farmers, and on the lobbying side, we're really focused on the cultivation supply side. It's a huge honor. The last piece about me is I teach cannabis law here at Albany Law. I'm a 07 grad and a current professor, adjunct professor. Always can get a promotion. But it's an honor for me to share this panel with these participants. When I started teaching at Albany Law, the first thing I did was I bought Rob's book and read it front to back. So, you know, it's a real honor to share the stage with him. I like to look at this, you know, from a state perspective, New York State market. You know, given my various roles on the legal and lobbying side, I think I have a lot of insight into the challenges that the state faces. And I tend to look at this from a data-driven perspective that I hope informs policymaking. For me, and definitely for my clients, the biggest issue that the New York State market faces is this thing we call inversion, which is an influx of out-of-state cannabis into the legal cannabis market. And that happens primarily through two ways. The first way is through illicit trafficking, and then the purchase of illicit trafficking by licensed processors, growers, distributors to introduce cannabis that was not grown in New York into the retail space in New York. The second way is really trafficking through the tribal nations. And that is a very different story, but one that has, both of these have significant impacts on the price of cannabis and, you know, policy decisions at the state level. The New York MRTA requires cultivators and retailers and everybody who participates as licensees in the adult use market to utilize what's called seed to sale tracking. There's been some delays in implementing seed to sale tracking, primarily on the technical side, but that program is so critical to market integrity. Without that program, it's really basically impossible to determine whether cannabis is from out of state or from in-state, New York grown, as the law requires. There are, outside of seed to sale tracking, some, I would say, pretty relatively new initiatives, primarily driven by multi-state operators called point of origin testing, where at least they allege they can determine where the product is grown and whether it is inverted product or is locally grown product, state grown product. But leaving that aside, seed to sale tracking as a market integrity initiative is the most critical policy development for the market because it impacts the entire supply chain, okay? And the Office of Cannabis Management announced that they were going to implement seed to sale tracking. Thank you guys in the audience. In the fall, it is beginning to be rolled out, but just to illustrate for you how important that program is, there's basically two different types of product. There's flower and there's distillate. Distillate's used for edibles and vapes and whatever, and flower is obviously flower. The price of distillate in November in New York was $6,000 per liter, all right? In California, it was $650 per liter. In the space of 30 days to 60 days after OCM announced seed to sale tracking, the price of distillate in New York dropped from $6,000 a liter to about $2,800 a liter. All right, and that is because product from California came flooding into New York. The price of distillate in that same time period in California rose from $650 a liter to $1,800 a liter. So there's an arbitrage event there, right? The producers in California saw that they could make a lot more money in New York, and they flooded the New York market with California cannabis. Having that kind of market integrity initiative, it's really the only way to ensure that we have a secure supply chain. It's a really critical initiative. And I kind of want to just piggyback on what Rob was discussing about with the federal level and rescheduling, because I think it's important. I think not just on rescheduling, I think there's a dream by advocates that the United States will become an adult use jurisdiction overall, all right? And I would say, and I say this to my students, that's a terrible idea for New York, all right? A terrible idea. New York can't grow year round. I mean, we have a lack of indoor facilities, which are very capitally intensive, which requires a lot of investment, which is typically only controlled by multi-state operators. So you really don't have small farms involved. Outside of indoor growing, you really only have outdoor cultivation. California, Florida, Alabama, whatever, they can grow year round. On top of that, if the United States would become an adult use jurisdiction across all 50 states, we would probably be in contravention of the single convention on narcotics, the United Nations. But you can rescind that. The U.S. could rescind their participation in that treaty, and they could, and the federal government could enter into agreements with other countries who have adult use cannabis. And that would basically mean the destruction of the cannabis cultivation space in the United States, because you could easily plant thousands upon thousands of acres in countries like Panama or Costa Rica or Colombia, pay for shipping, pay nothing on labor, and you would come out with a tenfold profit than you would have if you grew in the United States. So a lot of these issues are interconnected. Tribal nation rights and participation, federal government participation, local participation. It is, as the name implies, an ever-evolving landscape. But for me, as soon as we implement the seed to sale tracking, it will be a revolution, at least for the state marketplace.
All right, well, thank you so much. So we've got about 10 minutes for questions. This is on, it's just not enthusiastically on, I think. Just keep it close. Okay, I'm gonna keep it close. So I'd ask if you could raise your hand and wait for a microphone to be passed to you before you ask your question. I'm gonna start up here and.
Thank you. Matt, really appreciate your comments. I guess one of my questions is, aren't we already down that path of just market undermining and destruction with what's happening in the hemp space? Maybe not so much in New York, more so nationally, but still pretty much in New York, where hemp operators selling intoxicating hemp products, Delta-9, it's the same molecule, engaging in scaled manufacturing, national distribution, not the same limits or restrictions as state regulated products, direct to consumer sales through the mail. We see now even states that are prohibiting these products are still doing carve outs for beverages. Those are being widely distributed through the alcohol distribution chain. It's in Total Wines in Minnesota. It's in one of the larger chains where it's outselling, tequila and vodka with 15% of sales. So how much do we need to be concerned about the hemp market? And is that more of a threat than the current status quo in terms of federal prohibition and what's not available to current licensees?
Got the topic of the moment there. No, I totally agree with that. I think that is a very significant challenge. Certainly, we had experience in the New York hemp market that basically collapsed, which led to conditional cultivation statute, which basically gave hemp cultivators, after their market collapse, an opportunity to be the first cultivators in the adult use space. But to the point of selling hemp-infused beverages, there are already well-established supply chains, right? The alcohol industry has lost market share due to the substitution effect of cannabis. I think that issue is probably outside of I would say cannabis, the hemp infused beverage, is going to be an issue that's going to be tackled by the legislature this legislative session. I mean, I would not doubt that you see there's at least several bills I know that are going to be proposed that prohibit hemp infused beverages from being sold. And, to your point about undermining the market, New York has all these rules about setbacks and proximity to churches, to schools, to other dispensaries. Hemp infused beverage can be sold at a bodega next to a school, can be sold next to a church, can be sold in a supermarket, can be sold wherever beverages are sold. So I think it has a really significant potential to disrupt the marketplace. I agree with you.
Okay, great. Other question? And anybody else raise your hand? I think we need to stack questions if we have that option. So
Thank you. I guess this question is just for the panel generally. As someone that isn't so familiar with the space that cannabis law occupies, I have some trouble sometimes understanding how the intrastate market exists despite the federal prohibition. Is there anything that essentially legally protects the intrastate market besides a couple of, DOJ memos that basically say they won't enforce the Controlled Substances Act to the extent of the intrastate market, or does the interstate market more or less exist at the pleasure, I guess, of the federal government not enforcing it?
great. Why don't we take the next question at the same time if that's.
Was I on? Oh, this is really on. Piggybacking off of that, talking about at federal level, right now there's a case that was heard in the First Circuit late in December, early December of last year, going after the case. It's called Canada Provisions v. Garland, and they're arguing of trying to push to overturn Gonzalez v. Reich because which established this federal scheme of control for cannabis and taking aim at the fact that that no longer holds, that there are holes in that regulation because now multiple states have either legalized or decriminalized. So I guess my question is, do you see, in order to create, for cannabis to be legal on a federal level, do you guys believe that ultimately it will have to go up to that level in order to ensure that even companies and growers who are operating purely intrastate, which Canada Provisions in Massachusetts was seed to sale, are able to access those types of funding and resources? And ultimately, we need to overturn this old case in order to break through the next levels of legalization on a federal level.
Okay, great. And can I add one more question to the stack and then give it to the panelists? This is especially for Ms. Brunner and Ms. Higgins. I'm curious about the role that law enforcement has played in the development of these regulations, and if tribal law enforcement authorities, in your experience, local police have had views on the emergence of this industry, and if so, what role they've played in your experience. Obviously, anybody can answer the question, but I guess that's three, so we should give it to the panel who wants to start with.
Maybe I can take a crack at the first two questions. I think there's really a role that's being played by each branch of the federal government. So certainly the DOJ, really since the waning days of the George W. Bush administration, basically said, we're no longer interested in aggressively criminally prosecuting this industry. And it became more formalized. That sort of guidance became more formalized during the Obama administration with the Cole memoranda, where it was stated publicly, we're not giving you a right to do this, but we still won't touch you unless you implicate one of those priorities. So the DOJ can do that, but it can also yank that at a moment's notice. And maybe you favor that for marijuana, but also think about what the Trump administration is now doing, basically saying public corruption charges. Why are we bothering with those? Bribery. Why do we care about that? So you have to be worried about that sort of non-enforcement policy. There's also the legislative branch. Congress has basically attached a rider to the budget for the Department of Justice each of the last several years. It's basically said to the DOJ, you can't spend any money going after people who are operating in compliance with state medical marijuana laws. It's only medical side, not adult use. So that's a little bit more enforceable, although it has to be renewed every year. So if Congress doesn't renew that this year and you sold even medical marijuana last year, you could become the target of a vindictive federal prosecutor. It doesn't really give you any permanent legal rights. The courts, there's this Hail Mary lawsuit brought by some prominent attorneys trying to challenge Gonzalez v. Raich, the famous case where the Supreme Court said Congress has the power to ban even the intrastate cultivation and possession of marijuana. The courts might recognize more potent limits on Congress's Commerce Clause authority, and that might prevent Congress from at least criminalizing intrastate activities. I think it's, a 1 in 1,000 chance the court will actually rule in the favor of the challengers there, but it's another possibility out there. It's not necessary. Congress could do this voluntarily. I don't think there's only a limited amount the president can do. I think it's ultimately on Congress's shoulders, but each branch of government can play a role in kind of softening the federal prohibition.
So your questions around law enforcement and tribal law enforcement on tribal lands. So tribal nations have this sovereign authority to pass their codes, pass their laws, and to be able to grow, cultivate and sell cannabis on its own lands within its own jurisdiction. Our tribal nation encompasses about 1,300 square miles. It has 3 counties. One county in particular encompasses is encompassed by the tribe. And that particular, although we work well with the state from government to government, the local county is not always so nice. And so the county prosecutor was going to use the county sheriff's department and raid the tribe's cultivation facility. And right before that occurred, the governor and lieutenant governor paid a site visit to the tribe and to that particular facility. And so staff were asking me after the fact if the county were going to do the raid. I'm like, no. It would be political suicide for her to do so as the county attorney and its sheriff department to do something that you have the governor and lieutenant governor paid a visit to, because it's recognized in tribal sovereignty in that capacity. So, and as far as our tribal law enforcement go, regardless of anybody's personal thoughts on cannabis, they fulfill their roles and duties in compliance with our band's laws. So.
I think from a New York State perspective, we've seen a lot of non-participation by law enforcement. I'm sure you guys have seen that illicit cannabis has been a challenge in New York. Illicit cannabis stores, unlicensed stores, particularly in New York City, have grown, 1,000-fold. The legislature and the executive, both OCM, the Cannabis Control Board, and the governor's office have tried to put, give more authority to sheriffs, to local law enforcement to shut down these types of illicit stores. And that statute's been challenged. It's currently being enjoined. But at the same time, my experience is municipal police don't want to touch it at all. Don't want any part of it, whether they're legal or illegal.
From my perspective, just building on what Matt said, thank you very much. Cannabis being such a highly regulated market requires that the city had such significant regulations to make sure that there was no illicit operation. So you had to have your certificate of occupancy and you had to secure the proper permits, whether it was from the city clerk's office or the planning department or codes department. And so because of the existing planning regulations, you would have to seek out approval that required 4 or 5 different departments to sign off. So the codes department had to first sign off and approve the use in that particular facility or building. The planning department would have to sign off. So would the fire department for health and safety reasons, and then so would the police department. And so those 4 organizations had the ability to determine whether that building was appropriate for the current use, that there was a sufficient security plan to ensure that should there be any type of challenge, theft, fire breaks out, whatever it is, that the proper suppression materials exist and that law enforcement could respond appropriately without diverting significant municipal resources to supporting this private entity, but also ensuring that the local municipality is providing that support. And so law enforcement was engaged in the conversation. There were city advisors who staffed the committee just so that we could provide our own operational perspectives and understanding about the inner workings of what might be required. And so, yes, they were involved, but in terms of the policy, not so much as in a punitive capacity, more so just logistically. So we would bring in prospective operators of retail locations to sit down with our police department, with the codes department, with the planning department, and with the fire department, just to make sure that should there be an issue, they had the requisite support to operate their business and that the lines of communication were open. And that seemed to always work very well for our internal operations and then for the operators themselves.
All right, thank you so much. I'm afraid we're out of time. I want to say how grateful I am to Jasmine Higgins, Robert Mikos, Matt Leonardo, and Lisa Brunner for sharing their insights with us. To Chell Miller, Lisa Ravage, and everybody else at the Government Law Center. Don't forget to do your CLE paperwork. And I look forward to the next panel. Let's give a big hand to our panelists. Oh, we have a 10-minute break.
5 minutes. So testing, yeah, this does work. I emailed,
That one must be on the volume control there, but these
Yeah.
to be.
yeah, that one's very, good. The other one was fine. I sent a note to CB20 saying, hey, can you
Yeah.
so I think they turned it up a little bit too. But that one I'll
Is
plug
there
in.
another board in the AV room? Is that controls the mic? Because
No.
I think there's only one microphone control on this panel.
There's this, yeah. Yeah, so. Speech one is what I.
And it,
Oh,
yeah,
and
and it's
It went max and then I had to turn it back down.
most of ours
Yeah.
jump all the way the first time you touch the up button. I don't know what the hell that is, but
Yeah. Testing.
yeah, nerving, yeah. Right. My cough, by the way, is lingering, not
Yeah.
still
I have
contagious.
like
so
chronic sneezing and stuff because
Yeah,
I have
no.
allergies, so I feel like I always have to tell people like I'm not sick.
my doctor says I had COVID like it's been weeks now,
Yeah.
but
Oh, so it is
just
like.
still the
even
cough
after
from that. Yeah. Like hopefully it won't turn into long COVID, but it's already long. So,
Yeah, that's a little frustrating.
Yeah.
Did you take Paxlovid?
No, by the time I tested positive, I was more than 5 days into symptoms, so they wouldn't.
All right, good afternoon, everyone. I can tell this mic's on, so that's working and good. I got to say good morning to a number of you, and so now I get to say good afternoon, and I have the pleasure of helping moderate this last panel, but let me reintroduce myself. I'm Cinnamon Carlarne. I'm the president and dean at Albany Law School. And even though I already said it a couple of times today, I do want to say just a huge thank you to the Government Law Center and the Government Law Review, and to all the students in particular who've been involved. This has been a tremendous event. And also thank you to all of you for being here today. Now, without further ado, I get to introduce the panelists. And I will be brief because we have 4 exceptional panelists to speak on the topic of the equitable development in cannabis governance. And so we want to be sure that they have adequate time to speak and then give the audience plenty of time to ask questions as well. So I will just do brief introductions. So our first speaker today is somebody who I'm very proud to have known since she was a law student and gone on to do incredible things. But Kat Packer. Kat is the Director of Drug Markets and Legal Regulation at the Drug Policy Alliance, and she's also a board member and Director of Policy for the Cannabis Regulators of Color Coalition. And she is also a distinguished practitioner at the Drug Enforcement Policy Center at The Ohio State University. Our second speaker will be Professor Benjamin Varadi. Professor Varadi is an associate professor of law at our neighbor school of Vermont Law and Graduate School. He also currently serves on the governance committee of Firefly Gathering, which is a permaculture and earth skills education resource, and on the board of directors for Yoga Alliance. Our third speaker, and our third and fourth speakers will be joining us online today, is Mauricio Agudelo, who is the president of H20 Health Ventures, the investment platform for the Health Benefit Alliance. He's also an adjunct professor of cannabis law at Brooklyn Law School and private equity transactions at the University of Connecticut School of Law. And then last but far from least is Professor Stoa, who is also joining us online. Professor Stoa is an associate professor of law at the LSU Law Center and the author of the book Craft Weed, Family Farming and the Future of the Marijuana Industry, as well as numerous scholarly articles that address cannabis regulation and agricultural policy, in addition to his teaching in that space. So 4 fantastic folks. And so we're going to begin with Kat, who will get us kicked off.
All right, we're hot. This is really exciting for me, in part because Cinnamon was my torts law professor, and so it always feels like a full circle experience in drug policy, particularly when I get to come and talk at law schools, because it was while I was a student in law school that I was first introduced to cannabis law and drug policy. I had an opportunity to take a marijuana law and policy class my last semester at Ohio State University. It was taught by Doug Berman, and it was during this marijuana law and policy course that I got to see how inequitable and unfair our cannabis policies were and are here in the United States. At the time, there was Professor Michelle Alexander was teaching at the university, and she had released her book, The New Jim Crow, and taking this class and reading that book at the same time really motivated me to get involved in cannabis policy, in part because in Michelle Alexander's The New Jim Crow, she said that nothing has contributed more to the mass incarceration of people of color in the United States than the war on drugs. And I would go on to learn that over half of drug arrests in the United States were for marijuana. About 80% of marijuana arrests were for possession alone. And all across the country, Black and brown folks were about 4 or 5 times more likely to be arrested for marijuana, despite the fact that Black, brown, white folks use cannabis at similar rates. And when there are discrepancies, white folks are actually using and selling cannabis at higher rates. And so I had an opportunity right out of law school when many of my classmates were taking the bar exam. I went to go work for a marijuana legalization campaign. My mother was mortified. But I think a couple of years later, when I was asked by the mayor of the city of Los Angeles to start and run their Department of Cannabis regulation, and found myself as the first person of color in the United States to lead and run an adult use and medical cannabis program, I think she calmed down a little bit. But I found myself moving from Ohio to California to work on California's marijuana legalization initiative. And part of what motivated me to work on that campaign in particular was that it was the first time a campaign was really trying to center social justice in its marijuana legalization initiative. I think particularly right now where we have 24 states that have passed adult use cannabis laws. I see California setting the floor, and a lot of states have outdone them. up until this point, including New York. So I think that New York should be proud of itself that it as a jurisdiction was able to learn from the experiences that happened before, but really want to try and spend the time that I have talking about what I've learned over the course of the last 10 years as I've worked in the space, both in government as a local regulator dealing with some of the same challenges that were mentioned before, but also as an organizer and an advocate, because for me, legalization is not just a means for adults 21 and older to be able to buy cannabis legally. This is about social justice. This is about freedom. This is about individual liberties. This is about making sure that we have policies that are going to be fair for all communities. Rob Mikos was talking about how we still are dealing with a situation here in the United States where marijuana is still a Schedule I substance. A little bit of background, part of the reason why marijuana is a Schedule I substance and criminalized at the federal level is because we had racists who were at the helm of drug policy back in the day. A guy by the name of Harry Anslinger ran the Federal Bureau of Narcotics. This is the predecessor to today's DEA. And he thought that marijuana made white women want to sleep with black men. And that was particularly problematic for him. He suggested that all of the folks who were smoking marijuana were jazz artists and black folks, and that was problematic. And this type of kind of personal racism became institutionalized into systems at our federal level, carried on by folks like Nixon, who signed the Controlled Substances Act. It has since been revealed that Nixon's intention in placing marijuana in the Controlled Substances Act was not about public health or public safety, but he wanted to use it as a means to disrupt Black and brown communities and people who were against the war at the time. And we're still dealing with those consequences today. Rob talked a little bit about this rescheduling conversation, and just want to note part of what I advocate for in this space, and it seems much of a pipe dream right now, but what we need at the federal level is not rescheduling of cannabis, but descheduling of cannabis to remove cannabis completely from the Controlled Substances Act. That would place marijuana much like we treat tobacco and alcohol today. But we have an opportunity and challenge here in the US to develop policies that are more fair. And I think we've seen some of what that's looked like over the course of the last 10 years. A lot of these initiatives that have developed over the course of the last 10 years to try and make cannabis policy more fair have generally been referred to as equity programs. But hopefully we can spend a little bit of time talking about what that means, because I think that there's some hysteria around the term. And when I talk about equity, I simply mean fairness. We're talking about what policies are going to be fair for all communities, with an acknowledgement that policies have not been fair for all communities. This term equity in the cannabis space thus far has largely developed in 3 specific areas. There has been an effort to make sure that there's equity in licensure and equity in the market, so that people who have been criminalized by cannabis have an opportunity to participate in the legal market. There have also been efforts, as was mentioned previously, to ensure that the cannabis tax revenue is going back and being reinvested into communities that were most harmed. And lastly, the third prong of what's generally referred to as these equity programs are policies and provisions that have allowed folks to essentially get legal relief in the form of expungements, pardons, or commutations. And while I think that those efforts have been helpful in many regards, I think that we're still at a place where we're dealing with unfair cannabis policies at large. We know that you can buy cannabis at a store potentially across the United States, but it can still be the reason why you're denied access to housing, employment, education. It could be the reason why your children are taken away from you. And so we talk about equitable cannabis policy development, but to be frank, I don't think we have a real life example of what fairness looks like in cannabis policy in the US, because we're just not there yet, particularly when we're dealing with a situation where we're still completely illegal at the federal level. So for me, I try to focus on impact when I'm trying to assess a particular policy, is whether or not it's equitable. Who is this policy going to impact? What is that impact going to be? I think that these are decisions that policymakers, regulators should be asking at all levels of decision-making in cannabis. So my hope is that we take from the policies and programs that have been developed thus far and extend them to every single decision that's made in the development of our market. I guess the last piece that I'll add here is I have a concern right now about this commercialization of cannabis. I say this as someone who has regulated commercial cannabis before, but with the industry picking up steam over the course of the last several years, there has been less of an interest in the social justice elements of cannabis policy reform. It's easy to feel like the industry is leaving everyday consumers behind. For example, if you ask folks in the industry what their #1 legislative priority right now in Congress is, they'll tell you it's safe banking. I don't know any everyday consumers who actually care about safe banking. I haven't really heard about the war on banks. And yet that is what the industry has spent, tens of millions of dollars lobbying on over the course of the last several years, while people continue to be criminalized for everyday activities. So I think we still have a long ways to go. But what's important as we're moving forward is to recognize that this is everyone's responsibility. Equity is not just about Black and brown folks. It is a mechanism to ensure that all communities are treated fairly. And I think that we have an opportunity to get it right if we can recognize that this is something that we all bear responsibility for. And that we all have an opportunity to be adversely impacted by if it's not addressed. So excited to be here with you all. I look forward to chatting with you all during the Q&A.
Jump. I got a thing here. Oh, and a thing. No, that's too many things. That's okay. Hi, everybody. Well, while that's going, I will also say thank you so much to Albany Law School and the Albany Government Law Review. I was mentioning earlier, I actually grew up about an hour south of here, so it's wonderful to be back in the region. I have formative memories of attending mock trial competitions as a youth, and definitely don't have formative memories of cannabis deals in parking lots in Albany. But if I did, they would definitely be within the statute of limitations or outside the statute of limitations. And I told my spouse I might mention that. She said, absolutely don't. And I said, why statute of limitations? And she said, because it's trivializing and it's perpetuating the stereotype. And I said, is there a stereotype that law professors have bought herb in Albany parking lots? And she said, no, but you're really working towards it. But more to the point, when we talk about cannabis regulation, it can be a bit funny or fun or trivializing to talk about. And when we do that, we're a little bit getting away from this point that Kat made so eloquently, that the regulation of cannabis has been used as a tool of minority oppression really for 800 years, if you look at the full history. And when we talk about the moment we're in right now, it's so exciting because we've transitioned through these 800 years and we've built up these systems of injustice in all of these different areas, in cannabis regulation, in business, in all kinds of different areas. And this is a moment where states in particular have an opportunity to change that narrative, maybe for cannabis and perhaps for business law and agricultural law. more broadly. We have these ideas, and please don't read anything into the order of the guys down there. I'm bad at PowerPoint. But we have these ideas. Every president of the last 7 presidents has said small businesses are the growth engines of the American economy. They've said fair competition as opposed to unrestricted or unfettered trade is a fundamental premise of capitalism. And they've all said, although I suspect they meant different things, that racism is a problem that needs to be addressed. And it turns out that in this moment, we have states that are trying to realize that promise, that say that that's more than rhetoric. Because when we look at cannabis legalization, we look at the fact of federal prohibition, what it's meant is that we have an agricultural economy that's come up entirely free of big ag. We have a moment where each state has been developing its own regulatory approaches. And it turns out that when we let folks do that in the modern era, they say, hey, maybe we do want to prioritize small business. Maybe we do want to think about how within that process we can assist the folks who were harmed by prohibition. But we've created these circumstances where it's really hard to thrive in the cannabis industry for all small operators, but particularly for minority entrepreneurs. Cannabis is a capital-intensive business. Our traditional raise mechanisms are largely unavailable. Most banks not going to lend to cannabis businesses, period, because risk, right? Every loan is an evaluation of whether that business is likely to be able to make the repayment, and banks are actually required to balance risk in their portfolio. And that means that for the private lenders who are willing, there is a reduced competition among lenders, and they can translate that risk into higher interest rates. And some of you may have car loans or credit cards or mortgages and may be familiar with this concept that the riskier you are as a borrower, the more you're going to end up paying, the higher your cost of capital. And so we see these predatory environments, which create a wonderful circumstance for these large businesses, these MSOs, to start to develop or recreate that big ag model. And we see that it's absolutely a disparate impact for minority entrepreneurs. We know that minority business owners are disproportionately declined funding in all businesses. All small business owners from minority backgrounds statistically have reduced access to capital. In theory, we have some laws that could impact that. The ECOA, which is very, very hard to prove and requires a proof of patterns, which is awfully difficult when you're talking about a license capped regime where you may not be looking at apples to apples in terms of who your borrowers are. And the ECOA is administered or has been administered primarily through the CFPB, which is some of you, that is to say those of you who have read the news as of last night at least, are aware still technically exists as an agency. But what's going to happen in terms of administration and where the priorities are going to be in terms of assertions of race bias in lending, very unclear. And so states have said, we do need to do something about that. We do want to implement these social equity programs. And it's been an incremental process. There's been a lot of progress. And I don't want to say that those ideas don't work. But when we say, okay, the first question is, well, who do we want to help? Who were the folks who were most adversely impacted by the war on drugs? And then how are we going to extend some assistance to them? It turns out that if we say, well, we're just going to have a race-based preference, we end up facing equal protection challenges. I have a sense most of you have a sense of how that works. So there's been an idea of, well, let's create these geographic proxies. Let's say if you grew up in this neighborhood or if you're a resident of the state or whatever, those bring dormant commerce clause challenges. Some have been more successful than others, but the jurisprudence is militating towards shutting down some of that. And so we do see these other approaches, many of which work, often raise challenges, and both in terms of controversy, as in when the state of New York said folks who have been involved with the justice system and veterans are both will qualify for social equity consideration, and then the veterans got awfully upset when folks who've been involved with the justice system had licenses processed earlier. We also see dilution, as in New York. I love New York. I'm from New York. There's been a lot of stuff that's happened here, where we said we're going to look at It's not disadvantaged farmers. I lost my lecture notes. Distressed farmers, we're gonna consider them a qualifying category within our social equity provisions. The USDA reports that the average income on United States small and medium-sized farms that's actually derived from farming is negative $2,000. Every farmer is a distressed farmer in New York and pretty much everywhere else. When you add big ag, the average is still negative $900. So we see dilution, but there are some opportunities there. There are some of these proxies that have held up. And we say, all right, what are we gonna do once we know who we wanna help? We gotta figure out what we're gonna do. And to Kat's point, there are these questions of impact, right? So we can say, well, we're gonna discount licenses. This is not a huge economic opportunity. We can say, we're going to issue grants. That's amazing if the grant money is enough. In Vermont, we went ahead and authorized $500,000 for our grant program for the entire state in perpetuity. If this was a class, I'd frame this as a hypo. This is about half what it costs to start one dispensary if you're lucky. New York took a different approach. They said, we're gonna lend out directly a little over $200 million, but we don't actually have $200 million. So we're gonna go and find some folks who are willing to back us in terms of direct lending. And some of you know that there were substantial scandals around that. So what do we do? What are the other options? Some of this stuff works. None of it works as well as we'd like. One idea that I've been kicking around and pitching and writing stuff about is that maybe there's an underexplored mechanism in the form of state guarantees of private loans with rates inverse to creditworthiness, which is a wordy way of saying states vet borrowers in advance. Are you as an individual, are you as an entrepreneur coming to us with an idea that with adequate support, technical support and otherwise, including these are the states, they control the markets. They decide who gets a license, geographic restrictions on markets, everything else. If we grant you one of these oligopoly permits, essentially, then is your business likely to succeed or fail? Once we vet that, we say, okay, well now we'll refer you to a private lender, but we'll underwrite we'll guarantee the loan. And some of you might be familiar with this idea if you have had guarantors on car loans or student loans as of this morning. Many of them were still guaranteed by the federal government. In those circumstances, that drops the risk effectively to zero because it turns out governments are pretty easy to find and recover from if somebody doesn't pay their bills. And importantly, the government underwriting model works really, really well in small business and ag contexts. There's a concept of what is called the subsidy rate. Essentially, how much did the government spend on this guaranteed lending program? To analogize, if you have a grant, if you just give away money, subsidy rate, 100%. The subsidy rate for USDA guaranteed loans, and remember, average farmer, negative $2,000 is slightly negative. They're making a small profit on these loan guarantees, even within a private lending system. The SBA sets a target for their 7A loans of 0 as their subsidy rate, and they hit it. But our states don't even need to break even. They just need to cushion the risk to meet the policy goals relative to equity and otherwise. Because unlike general businesses, they have these larger metrics, including economic impact, employment. They also control the cannabis market. So we know already, the quote on this is the biggest winners in cannabis legalization have been the states. The only winners in cannabis legalization have been the states due to the tax revenue. Most cannabis businesses not profitable, in part due to 280E. There are certainly some other reasons for that, but the states are doing just fine. So states can spend money, they can hit a target subsidy rate, they can support small businesses, and in aggregate, they can come out ahead. And when you say, okay, when we go to the private lenders, this gives us an opportunity to do something really kind of magic. Because what we can do is say, hey, what if we peg the interest rate to your credit score, but we invert it? Low score, no problem. Better interest rate. We're going to give a preference. Why? Because low credit scores are a fantastic race proxy that's thus far been entirely constitutionally resilient. Every time lenders get taken to court and somebody says, hey, the way you're lending out money seems pretty racist. What with only rich white people getting the benefit? The response is, these are facially neutral, objective criteria. It's just the numbers. It's just the computer. And so that leaves us in a situation where there's one of two options. Either we accept that, that works, we have a race proxy that's constitutionally resilient, we can go ahead and lend and give a benefit to minority entrepreneurs, or somebody can challenge that. And what are they suing? What are they challenging on a theory of? We need to tear down all of the race bias in bank lending in general, all of the ways that we have been introducing and supporting systemic bias within our credit rating systems, which in that situation, the approach fails, equity wins. So it stands, equity wins. It fails, equity wins. Either way, we find ourselves in a stronger position. There's another possibility, which is what if lenders actually, due to the ECOA or otherwise, just start to get less racist in their credit scoring? If that happens, that's perfect, because then the market takes over and equity wins. Because now our lenders are competing directly with each other. The lending pool opens up, the interest rates drop. So equity wins in that circumstance as well. I pitched this idea to some regulators a while ago who said, that all sounds amazing. We don't know who's going to pay for it. I think there's a pretty simple answer to this. They liked it, although they haven't done much more with it yet, which is to the extent that states aren't willing to just jump into this entirely, we can use municipal bonds or state bonds, essentially, which will term as municipal bonds. Essentially, we know how much money is going to come in from tax revenue. We know the states can adjust things to ensure that that happens. We know that they can spread their own risk across the entire industry. And it turns out that state-issued bonds get to circumvent a whole heck of a lot of the financial regulation that says things like you can't trade cannabis securities in US public markets, which means that when you have these highly volatile stocks like cannabis REITs or ETFs or Canadian MSOs, and all these folks are trying to figure out what to do with that, now you have these super stable bonds that still fit within the investment profile, that still relate to the industry, but it's a much more attractive product for investors. I think that's what I got for you all. I have no idea how I did with time, but thank you very, very much, and look forward to chatting more. Oh, you know, I'll leave it to the expert. Thank you. Oh.
Yeah, let's do that. Who's up first?
Oh, we were muted. Professor Agudelo, you're up. Let's make sure we can hear you okay.
Yeah, can you hear me?
Perfect. Thank you. Yes, you have the floor. Thanks so much.
Okay, thank you so much to Albany Law School, to the dean, to all the co-panelists. I usually like to start off my classes with an anecdote. Perhaps not unlike let's see, Professor Varadi. I too had a bit of a, let's say, a dust up with the law in my youth. And I was arrested for possession of cannabis when I was 16 years old. And at that time, I didn't know the kind of disaster that I was really flirting with, right? It was really a tale of two individuals. On the one hand, I was a pretty good athlete, a pretty good student, and lived in a pretty good town. On the other hand, I was a Colombian immigrant, not yet naturalized, presenting as a foreigner, more or less. And I didn't know the kind of risk that I was tangling with. I didn't know the kind of consequences that came with something as passive as smoking a little bit of cannabis, which all of my friends were doing of all races, you know, white, Asian, black. We were all just kind of doing what teenagers do. And so I was presented when I came before the judge, you know, the judge was very lenient, said, you know, kid, you got a choice here. You can straighten your life up, or you can be one of these statistics. And the statistics that Kat walked through earlier, you know, the idea that Black and brown individuals are, and by the way, I'm an immigrant from Colombia, South America, a country that has a deep and sorrowful experience with cannabis and with you know, other controlled substances. You know, you can be one of these statistics, or you can change, you can do better, you can do different, you know, you can get your act together. And so I did, went on to law school at Brooklyn Law, and now I teach there. And so my experience with cannabis has been a deeply kind of personal one that could have derailed my professional ambitions, my opportunity for everything from loans to acceptance to schools, to all the things that we know, all the troubles and the prejudices that we've already discussed here, and that we can imagine elsewhere. And so kind of like, you know, Kat, when she spoke about the idea that thinking about leaving a respectable profession to go and advocate for cannabis, for an illegal drug, created a bit of agita and you know, and her parents. The same with me. I was working on Wall Street, and in 2016, there was an opportunity to start a fund that was focusing on international investing. I was working at an investment bank. I was doing all the things that you're supposed to do after graduation. And I could feel the tide changing, both politically and commercially. And so I explained to my parents that I was leaving my job on Wall Street to go and try to raise money for cannabis operators. And my mom essentially fainted and was like, okay, you can't do that. That's not what we raised you for. You already did this once. You're already arrested for this once. And I was like, no, Mom, it's different this time. You know, it's 20 years later. We're at the precipice of federal legalization back in 2016. That was very optimistic all those years ago. And so I was able to kind of use the skill set that I accrued both in law school and in business school. I raised capital that we deployed in Europe and South America. And so I've seen the equity question both individually and commercially. And my perspective now, as I teach both cannabis law and finance law, is that I think that we're going to have and include solutions both from policy and commerce in order to be successful in the long term. Policy will try to engage in the kind of perhaps redistributive mechanisms that we have, both legal in the creation of rights and the distribution of perhaps wealth as it is taken in by the government through taxes or other means. And then commerce has to step in, and the free market has to step in and do its part, right? I've been able to raise capital and to do so with really kind of, I guess, race neutral co-investors. And the idea is that we look for accretive investments that will return at least the hurdle rate, what we're looking to receive in our portfolios. And it has for a while been one of the private mechanisms to join with a licensee that has benefited from that early licensure of that we come through the various states that have offered early licensure for diversity individuals. Now, what I've seen in the private sector, however, is that there is still a predatory element to the loan institutions that have arisen in the private markets. There are certainly default provisions. There are provisions for penalties for minor defaults versus major defaults. There are kind of mechanisms for, in the markets, we'll call them essentially loan-to-own mechanisms that will invite the individuals with capital to take over slowly through appointments on the board of directors, through appointments in the executive officers, control, to wrest control from the individuals that were originally given the licensure. And so these issues are deep, they're abiding. There's no policy that essentially can forestall it, because the anti-alienation provisions, you know, when you're granted one of these licenses, you can't sell your shares for sometimes 3 to 4 or 5 years. Those will expire, and they're set to expire. So my personal experience, my interest in the reforms that I kind of help to bring to the private capital markets are interests that want to be long-term partners, want to be not just equity partners that end up competing for and sometimes wresting control. But as Professor Varadi stated, capital partners that are in the fixed income space, that are in the loan space, that are in the security space, in the bonds or leveraged loan markets, that we can provide private capital solutions to the good work that's being done on the policy side. And so it's a tough and long road. It's one that is essentially being reformed one investment partner at a time, but I think there's a great deal of promise. And so I'm looking forward to discussing what those opportunities and mechanisms are. And again, thank you all for having me, and I'll yield the floor.
Thank you so much. And now Professor Stoa.
Excellent. Thank you, Dean. And thank you to Rachel Brown and the organizers of the workshop. It's a delight to be here. I'm honored to have been invited, and I apologize for not being able to make it in person, but it's been a pleasure and super interesting to hear from the other panelists. I'm going to talk a little bit today about some business conditions that I think are sort of getting in the way of certain equity programming, as you might call it. Can you guys see my screen, and can you hear me okay? Excellent. All right, so I'm going to talk about somewhat of a narrow topic, but I think it's part of a broader conversation about how to make market conditions favorable for small businesses in the cannabis industry. So I'm going to be talking, the narrow topic here is on-site consumption and the cannabis farm. We know, of course, that any state that has legalized, medicinal or recreational use has licensed cultivation to some extent and issues licenses to cultivators. There are also a smaller handful of states that have begun implementing, to a modest degree, some public consumption opportunities or some consumption lounges. But what we still haven't seen in the cannabis industry is the marriage of those two developments, of states licensing and allowing cultivation sites, small scale growing operations in particular, to also have consumption take place at those facilities and possibly even distribution. Fortunately, there's sort of a precedent for this in the craft brewing industry, and so I'm going to draw on that analogy to sort of demonstrate why I think this might be promising and perhaps a good model to replicate in some contexts. So I want to start with this graph here. This is the wholesale price index of raw flower cannabis in legal markets. It starts in April of 2015 and goes all the way until last year in 2024. And what you can see here is, I think, very important and has a number of implications for the cannabis industry and for, I think, any attempt by a state to try to spread the benefits of legalization around. You can see that around 2015 or early 2016, wholesale prices of raw flower per pound were at their highest, at least in this period. It reached almost $2,200 a pound. That dipped. There was a resurgence during COVID, and now we've been in sort of a sustained bottoming out period since around mid to late 2022. It's now around 900, or less, a little bit less than $1,000 a pound. So the implications for this are pretty severe, regardless of how you want to define. If we're thinking about license equity, as Director Packer articulated, one of the definitions of equity, if we're thinking about issuing licenses for equity purposes, and to sort of, if the assumption is we want to spread benefits around. I think one of the mistakes that states have made in their equity programs is that they are assuming that a license to operate is this golden ticket to wealth and prosperity, and that all the state really needs to do is facilitate access to the market. And then, as we all know, we're in a green rush, and people will be able to make money. And I think that's a flawed assumption. I think that states need to be doing a little bit more to create market conditions that make, you know, business viable and that make it sustainable. Even if you can identify the people or communities that you want to receive licenses, even if you can get over the constitutional challenge and get them those licenses, even if they can get startup capital, you still need to create a sustainable long-term picture that allows the cannabis industry, and in particular small-scale businesses, to survive and ideally thrive. And this doesn't just affect, this sort of price collapse doesn't just affect small-scale growers. If you look at, for example, sort of the stock price of publicly traded Canadian cannabis companies, you'll see a very similar chart. And a lot of them have bottomed out in the last couple of years. A lot of investors fleeing from cannabis equities for the very simple reason that very few of them are actually making a profit. And so I think creating market conditions is really important. I'm in particular interested in how we can create sustainable market conditions for small-scale growers and small-scale agriculturalists. A little bit about my background here. This is kind of an embarrassing and shameless promotion of my work. But just so you know, I come from a background in which I'm thinking about the cultivators, the growers in particular, and also trying to promote sustainability of family farms and small-scale growers in the cannabis industry. For example, one of the policies I've worked with the state of California in implementing is this idea of marijuana appellations. So this is modeled after the wine industry. But in wine, if you purchase a bottle of Napa Valley wine, we have regulatory authorities that give you some confidence that a certain percentage of the grapes that were used to make that wine actually come from the Napa Valley. And I think this has a lot of potential in the cannabis industry as well. This would allow, if you adopted so-called cannabicultural designations of origin, you would differentiate products. So producers in the Hudson Valley are not competing against producers in Humboldt County, California. Some of that incursion that we were talking about in the first panel would maybe be less pronounced, or at least less significant. So let's think about the craft beer industry and why I think this might be a useful model in certain cases. Sometimes I think people misunderstand the point that I try to make in some of these conversations. And I'm not arguing that small scale growers are going to dominate the industry, or that there's not going to be any consolidation, there's not going to be any commoditization of cannabis. On the contrary, I'm trying to think about policies and laws that would allow sort of a parallel market, a craft market, to exist alongside the so-called big marijuana. And you see that in the craft beer industry. I think that is possible, that craft beer can coexist. I mean, in the United States, we have sort of two huge beer conglomerates, those being Miller Coors and Anheuser-Busch. Then you have thousands of smaller craft beer operations that can be successful alongside that. We've seen a rise in the United States of breweries. This sort of starts around the late 90s or early 2000s and really explodes in the sort of 2010 to 2025 range. We now have almost 10,000 breweries in the United States. That has led to an increase in employment and jobs generated at U.S. breweries. This graph just goes until 2017. But I looked at data for 2023, and the employment at U.S. breweries now is in the order of 90,000 or more jobs at U.S. breweries. So the question then is why? Why has there been this sort of craft brewery revolution? Why do we see so many breweries, so many jobs, and so on? And it's obviously a complex multitude of factors, and I'm simplifying greatly here. I also don't purport to be the world's expert on craft brewing or regulation. But in very basic terms, some of the policy developments that led to or opened up the sphere to smaller players. In 1978, Congress legalized home brewing. And this is something that I think sometimes is getting lost now in the sort of equity or marijuana legalization conversation. We'll talk about that in a second. Subsequent to that, I think states around the country did a couple different things. They legalized on-site consumption, meaning the location, the facility that brews beer is also allowed to sell beer at that location. You can serve beer at that location. And that had a number of different benefits, primarily creating or providing an opportunity to generate additional revenue. For a lot of breweries around the United States, a lot of the revenue is coming from the beer that they sell on site, as opposed to any beer that they're shipping or distributing elsewhere. The third development, and this one is a little bit more controversial, but in some states, they also allow on-site distribution of craft beer, meaning that you can go to a brewery. Not only can you drink a beer there, but you can also buy a six-pack and take it off-site. That's not true in all states, but it is possible in some. As I said, that's been a little bit controversial. Some other players in the alcohol industry say that's unfair, that's a competitive advantage. They're operating, without essentially operating as a distributor without a distributor license, to which I say, that is kind of, in the cannabis industry, that would be the point, to try to give some type of competitive advantage to smaller players. So how might I think this is analogous to the cannabis industry? For one thing, I think that we still need to be focused on and think about personal cultivation laws. I think this got lost a little bit in the last few years when thinking about equity, but some states have started to move away from allowing each individual to to grow a certain number of plants at home, and considering, sometimes when we're thinking about the cost or the difficulty of going to a dispensary to address medical or spiritual recreational needs, I think it's important to still have the sort of safety valve in the market. And so I urge states and regulators not to prohibit home growing in that regard. Secondly, I think there's a lot of benefits to allowing cultivators to sell or to allow consumption on site. Not only would this create an additional revenue stream for small scale growers, I think this would help create a little bit of education on what cannabis looks like. I think a lot of people at this point know what a brewery looks like, and maybe people who are enthusiastic about cannabis have been to a dispensary, but not that many people have been to a growing facility. And I think that this would sort of demystify that process, remind everyone that this is an agricultural product and that it is something that needs to be grown. And I think that creating that tourism would help as well. I think one of the other major benefits to this proposal is that it creates, or at least addresses, public consumption concerns or public space concerns. We saw in the first wave of recreational legalization, states realized pretty quickly that certain people were still not allowed to legally consume cannabis. And the reason for that is because there wasn't any public space to do so. States, generally speaking, don't allow you to consume cannabis in public. You can't consume in a public park, you can't consume on a public sidewalk. And I think the assumption was, well, you can smoke at home, you can consume at home. But if you're a tenant and you're renting from a landlord that says in your lease that you can't, consume cannabis, you can't smoke, then there's really nowhere that you can legally consume. And so some states have recognized that, and they've rolled out so-called consumption lounges. There are 10 to 12 states today that allow and license some type of consumption lounges. Some of these are standalone lounges, meaning they don't do anything else except create a consumption lounge. Others are married to or adopted alongside a dispensary, but very few, and to my knowledge, close to none, are married to or exist alongside a growing facility. So I think that simple change could provide a lot of benefits. Sort of the last piece of this, and I think this is sort of case dependent on whether or not this is advantageous to the state, the county, and the municipality, and that's on-site distribution. So not only would you be allowed to go to the facility to consume as sort of a consumption lounge, but you may also be able to purchase and then take home with you. Again, this is an additional source of revenue. But I like this too because it provides a little bit of transparency. You know, we talked about in the first panel some problems with seed to sale and consumers not necessarily knowing or trusting where their cannabis comes from. It's hard to really have significant trust issues if you went to the growing facility yourself and took it home with you. Obviously, there's going to be some challenges to this. I think a primary challenge here is going to be zoning issues. You know, zoning the state or municipalities' zoning power allows them to dictate where certain uses are going to take place within a city. For indoor growing, for example, a lot of indoor grows are taking place in areas zoned for industrial use. They're taking the warehouse district, for example. For outdoor grows, they are zoned often on agricultural lands. Well, now if we're introducing sort of consumption lounges to this equation, I think that's something that both licensees and licensors, the state, are going to have to navigate. I think there might be public health regulations and sort of traffic safety issues that should be navigated. Obviously, I think that this presents a problem with breweries and wineries that you know, our sort of traffic patterns necessitate driving to, and our society broadly accepts that sort of tension. But I think it'd be ideal if the cannabis industry sort of were thinking about this and on the forefront of providing some safe transportation options in that regard. On-site distribution, I think, runs into sort of an additional layer of regulatory complexity when it comes to dispensary regulations. We saw that be a little bit of a challenge in Colorado when they first legalized and required vertical integration. I think there was some pushback from regulated entities saying this is, you know, too much regulatory complexity for any one firm to take on. And then, of course, you know, you're going to see some industry opposition there. Dispensaries aren't going to like it if they're not sort of the clearinghouse for selling to the public and for growers to be able to sell directly. So you're going to see that opposition as well. I think these challenges can be overcome, but they bear mentioning. So that's my modest proposal. One of, I think, what could be a package of policy approaches for states to consider in trying to create a market condition for small scale growers to be profitable and to even thrive in the sort of modern legal cannabis era. Thanks very much. I appreciate you all listening.
All right, thank you very much. What we're going to do is have about 10 minutes for questions now. And so I think we have a couple of mics that we can move around. So if you have a question, please raise your hand so we can bring you a mic. Okay. Oh, there we go, because I was about to say, I got plenty. All right, here we go.
The panel spoke at the beginning about, I guess, a want for there to be movement on the federal prohibition that currently exists and potentially rescheduling or descheduling marijuana. My question is, are current players in the industry actually interested in seeing descheduling marijuana when it does kind of create this closed interstate market? And furthermore, if we want to see movement forward, say descheduling, would that maybe require in some sense reaching across the aisle to the agricultural interests and getting them to exert their sort of political capital in Washington?
Thank you. First taker.
Yeah, sure. I think that there are absolutely industry players who do not want to see descheduling. It does not serve their bottom line. There are these state siloed markets where these industry players have fiefdoms where they don't have to compete with the broader economy and market. Right now, there's no interstate commerce, right, of cannabis. And if there were interstate commerce, then folks would have to open up and compete. You can see where the lobbyists are going to put their dollars. And I spend a lot of time with these lobbyists. And what they want right now is what they call their trifecta. And for them, the trifecta is 280E tax relief, which would come through rescheduling, safe banking, and they'd also like access to capital markets and the stock exchange. Those are things that are not going to help the average everyday consumer that's dealing with consequences. This is something that I don't necessarily think we're going to get through the administrative process, this rescheduling. I think that this is something that's going to require Congress. I haven't seen a lot of indication that Congress is interested in moving in this as well. But I think the movement is going to have to reframe itself to try and deal with these political times. And I do think that that means reaching across the aisle, framing this states' rights, individual liberties, economic prosperity, et cetera. But regardless of where you fall, I think arguments can be made for reform.
Thank you, Kat. Other questions? Oh, yeah, go ahead.
I'd like to respond a bit to that. I think that the initial take on it is correct. I think that there are individual actors. Some individual actors would like to keep these moats and these restrictive areas where they have essentially the capacity to sell to a discrete population, right? If we were to reschedule or deschedule and essentially have a situation where there's an open and free market, that's going to not artificially, it's going to immediately depress the value of high cost production states. So if you can imagine that northern states where you have to grow indoors or in hoop houses, you have limited cultivation seasons, that cost of cultivation is a lot higher, but they have a discrete marketplace in which to sell their wares. You could imagine that lower states, lower kind of in our latitudinal system, California, Texas, Florida, states where you can have year-round cultivation, they would love to see the federal prohibitions go away because they would presumably benefit from larger, longer cultivation seasons, making the cost of their product lower and essentially outcompeting some of the northern states. So I think that you can characterize or you can break up those prejudices and preferences geographically and with the target markets that they wish to essentially serve. Domestically, we don't have a uniform regulatory system the way that the individual actors in the European Union and in South America have collectively decided. In Europe, the known standard for cultivation is EU GMP certification, European Good Manufacturing Practices. In South America, large-scale international cultivators have adopted EU GMP certification as the standard for export. In the US, we have such a fragmented state of affairs that all the states have different quality control and cultivation measures and standards. But if you are looking to export eventually, you're going to have to face two issues. Number one, the political morass of having that policy actually come to bear. But second, perhaps the cost of retrofitting your cultivation standards in order to meet the quality control and the quality metrics of that international market. So I think that it's absolutely correct that some actors are interested in making sure that they realize the value of their licenses by having those discrete markets to service. Others would love to open up a more competitive, more robust marketplace where low cost production benefits the end consumer. And yet others would like to essentially allow this more competitive international kind of practice to happen in order to benefit from the total addressable markets that are available elsewhere. So a very good question, one that there is no uniform answer to.
Well, we're short on time, and I want to return to kind of where we began with Kat and the question of equity is fairness and thinking about the kind of what we heard a lot about during each of the different talks, and if the commercialization has taken the emphasis off social justice, the kind of predatory nature of the private market, the way in which we've seen cannabis regulation as a tool of minority repression, these kind of themes that we've come out, and then think about them kind of where we are today. And just ask if each of our speakers, in just, I'm going to say like 30 to 45 seconds, could offer your thoughts on what your area of hope or focus or just kind of pressure is going to be in your own thinking and working on this space as you think about the next handful of years in this regulatory space, in this commercial space, what you want to focus on or what you want to bring light to or what you want to keep from kind of rolling back. And Kat, do you want to get us started?
Sure. For me, I think that I'm trying to advocate for there not to be a one model or one size fits all. I don't think that that's going to work. I think that we can have a competitive national market while at the same time allowing for things like personal cultivation, home grow, community cultivation. I think for me, it's going to be trying to recenter this conversation around freedom. I think we've created strange economic bedfellows with the money that's involved here. And the concern is that we could see commercialization turn into criminalization for folks who fall outside of the framework. And then that's my biggest concern is that post-legalization, somehow we end up with more crimes on the books than we did prior to legalization because there is an economic interest in that criminalization.
Thank you. Professor Varadi.
That work? Yay, there it is. Yeah, I think the data is pretty clear that improving equity and improving opportunities for small business leads to greater prosperity across our economy. And I think in this moment, we have a real opportunity to focus on that and to deliver that message in ways that can be heard in a bipartisan space, while also modeling what a national economy might look like if we didn't assume the end result of any new industry development was going to be monster consolidation with small carve-outs. If we said we can create opportunities for small businesses to compete, whether that's by way of creating opportunities in the craft sector, whether that's evaluating our relationship with cooperatives and space for collaborative economies or otherwise. And I think there is a lot of conversation to be had there about if what we're looking to do, whether it's from a pure capitalist maximize value, let's increase economic prosperity perspective, or whether we're saying, hey, we would also benefit from lifting each other up and building a stronger communities and more integrated economies. I think we can get to the same result either way. And that, to me, starts with our true commitment to supporting small business anywhere we can.
Thank you. Professor Agudelo, do you want to hop in? And then Professor Stoa.
Yeah, of course. Again, I'd just like to take 2 seconds to thank you, Dean, for inviting us and for the Albany Law School writ large. My interest in the private deals that I see, that I participate in, that I certainly help to syndicate, is I'd like to get some of those predatory terms out of the discussion that are just there on an everyday basis that are not commensurate with the risk profile of the minority lenders that take on these loans. So personal guarantees, depository account control agreements, short-term lending with balloon payments that are sometimes not explained correctly. All the things that we would do in the ordinary course to very low credit worthy borrowers are sometimes inculcated as a matter of practice in the private capital markets in the industry, specifically because we don't have access to banking. And so I think that to borrow an often used metaphor, that a rising tide lifts all boats, it is somewhat unfortunate that capital might be the tide that ends up lifting many of these, smaller kind of opportunities that are being sought by minority and disproportionately impacted individuals, it's just a balance. It's a weighing of interests. It's a trade-off of, does that access to capital then create larger operators that will squeeze out the kind of mom and pops, or does it allow natural selection, natural competition to come in and to see who's providing the best quality product at the lowest price to consumers to decide who's successful in the open market? Thank you.
Thank you. Professor Stoa.
Yeah, thanks. I'll just add two thoughts that I think are encourage me in thinking about the future. One is that I think states will retain an interest to provide mechanisms that provide some kind of a competitive advantage to the businesses in their state. Because of the interstate commerce restrictions, now each state has their own essentially cottage industry. And when those floodgates of interstate commerce are lifted, some states are going to be winners, some are going to be losers. And the ones that stand to lose, I think, will have an incentive to create the types of regulations that we might need to support smaller businesses. Secondly, I think it's worth remembering that consumers also have a voice in this. And as long as we give them sort of the information and transparency they need to make sort of their own consumer choices, consumers might express a preference for cannabis grown in a certain way, or from a certain region, or by a certain person. And I think that has been too in the sort of the analogy to the craft beer movement. I mentioned some legal reasons for the shift, but as well, I think a shift in consumer taste was a factor in that as well. So I think that consumers will continue to have a voice in this, and they will be able to play a role in promoting and making sure that the industry remains equitable. I'll leave by thanking the organizers and reminding everybody that Tuesday is Mardi Gras. So happy Mardi Gras to everyone. And I hope you all
Should have king cake.
have a great Mardi Gras holiday.
Terrific. Thank you so much. So please join me in thanking our 4 fantastic panelists.